Good evening, everybody. It is August 5th, 2021. I can't believe we are in August already, but it is Thursday and it is 6:30 p.m. And we are here for our weekly Facebook Live. And we do have a special guest today who I'll introduce in just a few moments. But before I do, just some quick updates on the firm and some immigration law. This is really good news for immigrant applicants in Florida. Excuse me. They have opened a second asylum office in Tampa. Typically, the entire state of Florida is under the Miami jurisdiction, where people who are waiting 4 or 5 years just for an interview. Hopefully, this second office, which has opened just on August 2nd, will help speed up those who are waiting for their asylum interviews in the state of Florida. So that's great news. We also saw the release and the specific instructions on Haitian TPS. So they made this announcement back in May, but just have designated it up until August. So for those who arrived this summer, you could be eligible for Haitian TPS. And Central Florida has a huge population of Haitian nationals. So this is good news for those individuals. And today we also got an approval of an individual from Venezuela on extraordinary ability. And he's actually just a young artist in his 20s, but has won awards for his short films and his photography. So we were able to get him a national interest waiver by demonstrating it is in the national interest of the United States to grant this individual permanent residency or a green card. So congratulations to him. That was exactly 2 years in the making. We filed it July 31st, 2019, and received approval on July 30th. So that's great news for everybody else. So today, as you know, we like to bring on different guests who can share their expertise in particular fields to help educate, the Mubarak law and Central Florida and Florida community to learn more about other areas outside of car accidents and immigration, and sometimes more specific focused areas. So I'm going to introduce my very good friend, attorney Richard Schwamm, who has been practicing for nearly 30 years. And it's really important you understand the nature of his experience. First of all, not many lawyers have trial experience, and even less have close to 30 years trial experience where they're representing your individuals. But he, interestingly enough, defended medical companies and insurance companies, hospitals for close to 20 years, and now is solely plaintiff. So a lot of times we say, oh, what is the other side going to do? What arguments are going to make? Well, he's made the arguments for the other side, and he was successful in that. So now he's doing a wonderful job for plaintiffs. And I can tell you firsthand that I have referred clients to him, and the amount of energy and investigation it takes prior to even taking the case is pretty incredible. He is a founding partner for Haliczer, Pettis, and Schwamm, and HPS Legal, and they are celebrating their 25th anniversary as a firm. That's incredible. We are celebrating our 5th year anniversary this year, so hopefully we have the longevity and success as this firm. And without further ado, I'm going to bring on my good friend and esteemed colleague, Richard Schwamm.
Wow. Thanks for that introduction, Naif, and congratulations on your 5-year anniversary as well, Mike.
Yeah, it sounded like a big deal, but now that I see 25 years in writing, I'm like, oh, there's still quite the journey ahead of us.
Like we've said before, it's a marathon, not a sprint, my friend. Just enjoy the ride.
So, Richard, we're going to talk about medical malpractice and medical malpractice litigation and trials. And before we get started, I do want to just kind of educate those who may not know, because everybody's types of believe malpractice is any mistake. So can you kind of explain to us what is medical malpractice, before we get into more details?
That's a great question. So again, thanks for asking me to join you, Naif. I really enjoy these chats. And the question you've asked me is one that we get asked often. People call and say, well, do I have a case? And I go through the explanation I'm about to go through with you. Medical malpractice is not just a medical error. in Florida, for example, in order to prove that there is a medical malpractice or negligence, you have to prove there's a failure to use reasonable care, what a reasonable doctor or hospital would do under similar circumstances. So I'm going to give you a good example. So if a man goes in for a colonoscopy, and after the colonoscopy, they tell him, we made a mistake because the instrument perforated your colon. We need to go back in and fix it. That is not medical malpractice. That is a known complication. Medical malpractice would be you're short of breath after a colonoscopy, you complain of some abdominal pain, and they send you home. And God forbid you pass away at home from a massive perforation and infection. That's the same complication, but in those circumstances, the complication was not recognized and dealt with in the appropriate way. So malpractice is not just an oops. It's not a judgment error. It's a medical mistake that is outside the bounds of what is reasonable and normal and causes serious injury.
So is it okay to say that, if it's a mistake that's common in certain procedures, that, kind of is not medical malpractice, right? It's kind of a known risk depending on the incident, especially with particular, procedures that are done or mistakes that happen.
That's true. So normal complications aren't malpractice. Now, the challenge, though, is a person who's receiving the medical care may not really understand, was that supposed to happen? Was that a known complication? Or was there a mistake made? I mean, negligence isn't a known complication. So what we oftentimes do is give people peace of mind. I think I've told you, out of every 54 phone calls, we take one case.
Right.
I think 53 per times we're explaining these issues to people. And sometimes we need to look at the record. Sometimes we can just tell. But if at a minimum I can give somebody peace of mind, that's valuable to them. It's valuable for me. They feel like they're well served. We don't obviously charge for those kinds of things. But that explanation is sometimes not always apparent to somebody who doesn't have enough experience with these situations.
And for those who don't know, I referred a couple cases to HPS, specifically Attorney Schwamm, and they hired an expert. There was all sorts of records obtained to be reviewed prior to giving any type of, opinion to the client. And for those who don't know, like personal injury, a lot of times our clients are surprised that with car accident cases, there's no fee, that they don't have to pay any costs in the initial representation. And this is the same is true with medical malpractice. HPS is doing this at their own cost when they are doing this investigation. And I think it's really important for people who have suffered some type of loss to at least have peace of mind to know, was I wronged or was I not wronged? Is there a case and there's not a case? So I do appreciate that you all do that. And I think it's really important, and it kind of gives, even for those who don't have a case, a little piece of justice to know that what the situation is.
Yeah, when we talk to folks about what we go through, we have nurses that work in our firm, and we may need to just review records, and that's a lower cost. But we might need to retain experts, and sometimes it's retain an expert that tells us no. If we retain an expert for $2,000 or $3,000 and the client is told that we don't think there's a case, we eat that. That's our cost of doing business. The only time we ever recoup those costs is if we take the case, move forward, and we prevail, and then the costs come out of the recovery. And sometimes it's $5,000, sometimes it's $125,000, and sometimes it's much more than that. It really depends upon the case and the injuries.
So, Richard, I know when you are exposed to these kind of cases for close to 30 years, not that you're a doctor, but you're very close to the healthcare system and know kind of what's going on. So COVID-19 is happening. It will not go away. And we're not here to talk politics on COVID or vaccines, but it has had an impact on our court system and on our hospitals. How have you seen this affect the healthcare system, and has it kind of trickled into your cases as well?
Yeah, so here's my quick perspective on that. I have enormous respect for the doctors and hospitals that have served us. I defended them for decades. As you see them deal with the crisis that they're faced with, if you don't have respect for medical providers, then you're just not paying attention to what they've dealt with, and that has not changed at all. The reason that we're what we call a low volume, high value, or high damages practice is I wouldn't want to sue a doctor just because I have a hunch he made a mistake, or in my opinion, he made a mistake. We're only going to take cases that are viable and significant. So as you go through COVID, the doctors are deservingly enjoying somewhat of a halo effect that they have indeed been the heroes and have helped save the lives of literally millions of people. So in our world, we still look at cases the same way, though. If a medical mistake is made that shouldn't have happened, and it's a violation of the standard of care, those cases, those clients deserve the investigation. They deserve the zealous representation, the aggressive advocacy that we bring. But now we've got a court system that is almost shut down for over 12, 16 months. It's slowly starting to come back, but now with the Delta variant, the courts are starting to clamp down on what trials will be permitted, what lengths of trials. I don't have 1 and 2 day trials. We've had trials in medical malpractice that are as short as a week and as long as 6 months in the courtroom on one case. So there's been a log jam. So there's not as many cases settling. There's not as many cases going to trial. But eventually, when things ease up and everyone's patient and you can stand steadfast, those cases will resolve. 94% of the cases settled in the past. That's going to be the same rate moving into the future. The problem is the cases you think will settle don't. The cases you think that will never settle do. So you have every case ready to go to trial.
We mentioned some things about the hospitals being overburdened or kind of at capacity. And obviously there's a whole different type of extra COVID stress placed on these medical care providers. Is the standard of care or reasonable mistakes, does that change under COVID circumstances? Is that a viable defense, or, not even just defense, but like a valid reason as to why medical malpractice may have occurred or not occurred?
Yeah, I'm going to break that down into 2 thoughts. So first, you've got patients with COVID that are being treated. And what if they're malpracticed upon? I think it's going to be very hard to prove that a medical provider trying to help an unstable patient suffering from COVID is guilty of malpractice. Number one, there's going to be some laws, I suspect, that will add some layers of protection. And I think those are hard cases to take. I haven't taken a single, quote, COVID case because I think they're too hard to persuade a jury that those doctors didn't try their best. But what we're seeing is there's less elective surgeries, less elective medical care, which means there's less opportunities for folks to be committing malpractice. So we are seeing a reduction in the number of cases. We still go through the same screening process. There's still mistakes being made, but there's fewer of those cases that we're hearing about.
Okay, so I guess my question is, if for these doctors that are doing elected procedures, and then they say, perhaps supplies are low because of COVID, or some kind of mistake occurred because they are overworking, that doesn't change their responsibility or standard of care, right? That's not a good excuse or defense. Like, hey, I messed up this particular arm surgery because we are short supplies from COVID or overworked or short space.
Right.
You see that as being like a defense or any type of thing that might come down the line as effect from this whole year plus of COVID?
I do not believe that will be an effective defense. If the doctor believed it was wise to take you in for a procedure, he presumably had the ability to do it and do it safely. And if he did it wrong, the same penalties of being sued are going to be there, just like the patient who's the victim has the right. If the doctor can't do it or isn't comfortable doing it or doesn't feel like it's safe to do it, he's the one who has the obligation to tell the patient and keep the patient informed. So I don't think that's going to be a good defense at all. And candidly, on my side, if that's their defense, they're in trouble, because then they can't defend it on the merits. Then, as I tell people, you know what? That sounds like an excuse, not an explanation.
Kind of admitted, yeah, I messed up, but I'm going to admit to this, but
not my fault. The hospital didn't have the supplies, or everybody was tired.
Right. I didn't mean to crash into your car. I was sleepy.
Right.
So
as that's not a very good defense.
That's not a pretty good defense for them. So when these medical malpractice cases, if they do not settle prior to litigation, what would you say is like the average time frame, or like, is it years, or give us some examples of cases where you might be having trials and how long the case has been kind of developed with your office?
Sure. So in our experience, very few medical malpractice cases settle early. Because when we take a case and file it, we're already almost 9 months to a year ahead of the other side. We've done our investigation. We've got our experts. They've got to play catch up. So first, very few cases settle early. When you do take a case, I tell folks the investigation phase, for me to even decide if I think there's a case, is 3 to 5 months. Requesting the records, getting the experts, doing the review, figuring out what the case is about from A to Z. Then you have to go into what's called a mandatory investigation period with the other side. That's at least another 90 days. Then you need another 2 or 3 months before you file the lawsuit. And that's when the lawsuit formally starts. Wow. At that point in time, you've got 18 to 24 months on average. So you're looking at a 2 to 3 year adventure of a medical malpractice case, which means the clients have to have enormous patience, have got to have the intestinal fortitude to hang in there for that very, very challenging process.
And then this time where you're working on a case for 2 years, 3 years, there's just going to be significant costs involved. How does your firm handle that or approach, the, I guess, pretty large cost that comes with going to trial?
So we front all the costs. So during the case, good example, I'm going to mediation tomorrow. I've worked on the case for about 19 months. All of the costs of that case we have borne. We have paid up front. I haven't been paid a single penny for any of my professional time, the hundreds of hours we've spent working on the case. If the case resolves, then the recovery is reduced by the fees and the costs. And I think everybody would agree, rightly so. And the costs of cases, if I look at my case list now on the low end, cases that are currently in litigation, I've spent $25,000. On the high end, some of the cases we've spent more than $250,000 just in costs. We front it. The client pays none of that unless we win. So it's a gamble. We bear the risk, but that's the business of doing what we do, which is why the lawyers that do this get a reasonable fee to do what it is that we're doing.
Why you guys probably take 1 out of 50 plus cases and spend the time researching and hiring experts prior to even getting hired, which I think makes sense when the stakes are this high. And, in medical malpractice, typically there is some kind of terrible loss, right? Or catastrophic loss where, we're talking about costs and trials and time periods, but somebody has suffered greatly, typically with these cases. How would you say you balance dealing with so much emotional turmoil for individuals who may have lost a child or a spouse or a parent? And how do you help them through that process, when talking about things that are so painful?
It's heart-wrenching, to be perfectly honest with you. I spent time over the weekend speaking to a client who has a child with a brain injury, and I had a chance to see them both on the video, and I've seen the child make strides. And I talk in terms of how optimistic we are. But this is a family that will have to deal with these challenges for the rest of the child's life. And when they're no longer there, they need to worry about how they're going to provide for the safety and well-being of that child after. So when you look at a case like that, if it doesn't pull at you and it's your heartstrings and take a bit out of you, then you're not the right lawyer to handle those cases. I'm going to trial in September involving a 39-year-old mom of 2 who passed away after having a diagnosable problem that we believe was missed. We have a trial in October involving this child I've talked about, and a trial in November involving a 48-year-old special education teacher who got too much medication that wasn't right for her and suffered a stroke. These are cases that are catastrophic and take a lot about you. But my job is not to allow the emotion to control my thinking, my analysis, my assessment. But it's important that we be able to relate to those clients and understand the journey they've been on.
I've sat on, I think, a couple of consultations with you, and, a lot of times it's hard for me to hear these stories. And, with immigration, I hear heart-wrenching stories all the time, but a lot of times I think the medical, or especially when a mother has lost a child, it's something that it's unimaginable. So I do, a lot of times people consider like ambulance chasers or something like that's not some type of ethical or spiritual work, but I do believe you are making a difference for a lot of people's lives. So I thank you for that. So we a lot of our clients are immigrants, and many of them may be undocumented or from different parts of the world. I can't tell you how many times people have said to me, I don't want to sue. I don't want to say anything. I don't want to mess up my case here in the United States. How can you explain maybe to them if they don't, are not convinced that I tell them we can pursue a claim for people who are undocumented, and for my clients who might not be citizens of the United States or might be becoming a citizen? Is pursuing a medical malpractice claim or personal injury claim going to affect their status or future here, or even ability to get a claim for their case?
Short answer is no. Undocumented immigrants absolutely have a right to move forward with a medical malpractice case, the same rights that United States citizens have. I often tell people the same thing, that when they've had something in their past they're concerned about, whether it was an arrest, and they say, boy, if I bring this case, all that's going to come up. Well, in most circumstances, that kind of act, it's referred to as a prior bad act, is not admissible in the case. Mm-hmm. So the fear should not paralyze you, and you're thinking about, do I have rights? You absolutely, positively have rights. And you should speak to lawyers when something under like the umbrella of medical malpractice, if you've got questions, you deserve answers. We use interpreters all the time to help us communicate effectively with our clients. And it pains me when folks don't think they've got rights under those circumstances. Please understand that you do.
And I can tell you and those watching, it's not going to affect your immigration status. There's other things you could do that are worse than pursuing what right or claim you have. And it's not a negative thing. And, I guess I appreciate them not wanting to stir the pot or believe that they're doing something wrong. But, if you have been hurt by medical malpractice, you haven't done anything wrong if you're trying to pursue a claim to behold. And nobody's mad at the medical providers, especially if, sometimes mistakes happen, and sometimes people make egregious mistakes, and you probably can be mad at them for certain things. We are going to wrap up in just a few minutes. Richard, what would you say is like some of the most important tips or mistakes somebody can make when pursuing or reaching out to an individual to discuss medical malpractice?
Well, I tell everybody, really, the first thing you can do is try to avoid having to call me, meaning be your best advocate, speak up, talk to your providers, be candid, and take care of yourself and those around you. But when, even despite those efforts, something bad happens, you need to reach out to get your very reasonable, fair questions answered. Don't be afraid to ask the questions. I can't tell you how many times in just the past 30 days you speak to people who are so hesitant, so reluctant. I don't want to bother you. I just have a few questions. I want you to bother me because it's not a bother. I mean, like I said, if I can give peace of mind to somebody, and if there's no case, but at least they know, rather than waiting more than 2 years, which is the limitations period, and then their rights are forever gone and barred. So the first tip, I think, is if something bad has happened, ask.
Yeah, and I think
it happened to me.
And I want to reiterate what you said. Like, if you're at the hospital or your physician, you need to speak up.
Yeah.
And we've seen too many times especially with African American women speaking up to their hospitals and having all sorts of blood clots and not taken seriously. And then these are things that might lead to medical malpractice. But at least speak up for yourself to the physicians or to the nurses to make sure that they're aware of any complications you may be having or may be feeling. I know this is a very heavy topic, and sometimes complex, but Richard, thank you for taking the time to be here today after a long day of work. I know you have a couple trials coming up, and might be one of the biggest sprints you're about to take on in your 30 years career, but I'm sure you're equipped to handle it.
I am, Nive. Thanks so much. I'm really, really grateful for the chance to talk to you like this. And if you have any questions or any of your folks have questions that I can answer, I'm more than happy to talk to them.
Now, really quick, for everybody watching, please follow us on social media, on our YouTube channel, or if you want to sign up for our newsletter. If you have questions or want to get a hold of Richard, feel free to reach out. And then it's August. Everybody's getting ready for back to school. So tomorrow we have prepared several backpacks with paper, pens, folders, free of charge to anybody who would like one, or if you know anybody who would like one, please contact us. We have a few limited supplies left, and we will be giving them out tomorrow. If you need us to hold on to them till next week, that's no problem with me. But tomorrow we will be giving those away. And I wish everybody a wonderful first day of school, and good luck going back in person and hopefully getting to know your classmates. And Richard, thanks again, and I'll hopefully see you around.
I'll look forward to it. Thanks so much.
Good night.